My colleagues will be talking more about conditions, issues, and fair housing. So just to give you an overview of evictions, this slide is particular to Cleveland courts, but generally applies across the board to all of our service areas. So an eviction would start with an eviction notice, and as you can see, landlords are required to give a tenant a notice to vacate in order to start the eviction process. A lot of times it'll say either 3 days or 30-day notices given. And just to start out and to be clear, a lot of people read that and think that they need to be out of the property in 3 days or 30 days, when in actuality, the 3 days or the 30 days is how long there has to be before a landlord can file the eviction hearing. So that doesn't mean you have to be out in those 3 days. It's the amount of time given before an eviction can be filed. Some of the violations for a breach of the lease, which could be one of the reasons an eviction is filed, is non-payment of rent, illegal activity, non-compliance with health and safety codes, or denying a landlord access to the unit. For an eviction hearing, currently with Cleveland, they are all virtual via Zoom. And if an individual doesn't have the ability to go or to participate virtually, they can go into the Justice Center and be in a room that's sanitized and participate in the Zoom that way. In Cleveland particularly, and some other courts have this as well, the parties have an option to mediate. And in Cleveland, they have mediators on each docket, and they can work with a landlord or a tenant to try to come to a resolution that would be different than a judgment on the matter. Ultimately could lead to a judgment, but just trying to get the parties to work together. If a judgment does occur and the judgment is in favor of the defendant, the tenant can stay in the property. And just to be clear, when I'm talking about this, plaintiff is the tenant, or sorry, the landlord, and defendant is the tenant in almost all cases. But if judgment is in favor of the plaintiff, the tenant, at least in Cleveland and some other courts differ a little bit, gets 7 to 10 days to move out from there unless something else is worked out. There was a study done with Case Western Reserve University and Legal Aid prior to COVID, where they talked with a lot of people who had gone through eviction court. And one of the things that kept coming up was that when asked if they talked to the court about the circumstances surrounding the eviction, the individual did not feel like they had the opportunity to talk about what happened. So explain why they weren't paying rent or explain what was going on in the property. So the breakdown below talks about that a little bit. So a lot of times a tenant would not even show up, and they would then get a judgment to move out of the property in less than 2 minutes. And in other cases, if a defendant was present but didn't have an attorney, it would still be less than 6 minutes. And then if a defendant was present and had an attorney, it was a little longer of a hearing. But as you can see, the numbers, only 5 out of the study group even had an attorney present. I'm part of the Right to Counsel team, which I'll be discussing a little bit later, that talks more about getting more representation in court. So the laws behind tenants' rights and remedies related to eviction are the Ohio Revised Code Chapter 1923 and Ohio Revised Code Chapter 5321. And they spell out the landlord duties, the tenant duties, rental depositing, the notice of termination due to what are called health and safety violations, which we'll discuss a little bit more later. Unlawful lease provisions, lockouts and utility shutoffs, which are essentially self-help evictions, not going through the legal process, and then security deposits. So the basic clauses found in most lease agreements, which I'll make note of, that leases can be oral or written, but just going through the basics that are found in most, a lease will describe the term of the tenancy, the termination and renewal, which can be very important because I've definitely had clients who have not realized what the renewal process was like and ended up in a lease for another year, or they end up getting their monthly lease amount increased without realizing it. And also back to the term of tenancy, a lot of terms of tenancy are month to month. They could be year to year, kind of whatever the parties work out. It can go through the rent, the payment method, and the due date. It talks about the late payments usually, and it's important to note that late fees cannot be over 5% of what the rent is, or $25, whichever is higher, or sorry, whichever is less. It talks about security deposits, utility obligations, which can be extremely important to know who's responsible for what, as there can be evictions based on utility obligations, and also just, if there's a shutoff issue or something, knowing who's responsible for those payments. There is a right of inspection, oftentimes in leases, but that exists regardless. If a landlord gives 24-hour notice, they can enter the property. Unless there's an emergency, then it could be less notice. And the lease is also supposed to include contact information for the landlord. There are some things that cannot be included in leases, and as you can see here, they can't waive or modify duties that are found under landlord requirements. They cannot make a party pay attorney's fees. They can't warrant the attorney to confess a judgment or a missed liability. And a landlord cannot limit their liability imposed under the law, so they can't make a hold harmless agreement for various things. And generally, a court will look to a lease whether it's consistent with the statutory obligation before enforcing it. So if there is a portion of the lease that a landlord's relying on that doesn't comply with the law, the court will first look at the lease provision before determining that the lease can or can't be enforced that way. I'm going to briefly go through the tenant's rights and remedies, and also the landlord obligations. Barb, my colleague, is going to be touching on that a bit more, but landlords obligated to keep a unit in fit and habitable condition, keep common areas safe and clean, comply with building, housing, health, and safety codes, keep all electrical, plumbing, heating, and ventilation systems and fixtures in good working order, maintain appliances and equipment supplied by the landlord, and provide running water and reasonable amounts of heat and water, unless there's a direct hookup for the control of the tenant. Some additional obligations, we kind of already talked about the 24-hour notice. If the landlord owns 4 or more units, then they are required to provide garbage cans. They are required to evict a tenant when informed by law enforcement of drug activity by the tenant or by a member of the tenant's household or guest. So even if it's a guest on the property, it comes to the tenants. It relates to the tenant's tenancy. And then lead issues, which again, Barb's going to be addressing more later. The tenant obligations include the duty to maintain the unit in a safe and sanitary condition, to keep plumbing fixtures clean, use appliances and fixtures properly, follow applicable housing, health, and safety codes, not damaging or destroying the premise. And then guests, as we talked about, tenants are responsible for the actions of guests unless the tenant is uninvited. Unless the guest is uninvited. And to maintain any appliances supplied by the landlord. They also tenants are required to not disturb peaceful enjoyment. So, playing unnecessarily loud music, tormenting other people on the property. Like we talked about, not violating state drug laws, allow landlord reasonable access. So that 24 hours, or if there's an emergency, less time. Some rights and remedies that a tenant has if the landlord does not comply with those things is to terminate the tenancy, sue for money, sue for injunctive relief. Landlords can sue for possession, which is where the eviction action comes in. And tenants can deposit rent, which Barb is going to be discussing the rental deposit procedure. If the landlord violates the lease or the Ohio Revised Code, the tenant may be able to rent deposit They might be able to file claims for rent reduction or get orders from the court mandating landlord repair, or they can terminate the rental agreement. So self-help is the note self-help evictions are not allowed. So this is basically if a landlord tries to get a tenant to leave the property without going through the legal eviction process. And that can be done in all sorts of ways, whether that's turning off the utilities, locking a tenant out of the property, threatening an unlawful act against the tenant, seizing or bothering the tenant's possessions. Even if the tenant has breached some part of the lease, until there is an eviction judgment, the landlord cannot force a tenant to move out and cannot do it through trying to force them out in another way. Additionally, if a landlord is upset by something that the tenant does, whether that's complaining to the city about an issue on the property, complaining to the landlord themselves about a violation, or joining with other tenants if there is like an apartment building, they cannot do things that would be considered retaliation against the tenant, such as threatening them or decreasing their service, increasing their rent. If retaliation is to happen, this could serve as a defense in an eviction action. It could also result in the end of a rental agreement and potentially damages and attorney's fees depending on the level of egregiousness of the retaliation. A lot of the typical reasons for eviction include a termination of the periodic tenancy. So if it's a month-to-month lease and the landlord does not want the individual in the property anymore, they can terminate the lease that way, and that could end up resulting in an eviction. Expiration of a fixed term tenancy. So if it's for a longer term or a set term and the tenant is still remaining in the property, a landlord can evict that way. If a tenant does not pay the rent, then there can be an eviction. Or if a tenant breaches, which the Ohio Revised Code 532105 obligations, those are like the health and safety violations, they can end up evicting for that. Or if there's another lease obligation, if it is something that's acceptable in the lease that a tenant ends up breaching, there can be an eviction for that as well. There are some additional protections for subsidized housing. So subsidized housing generally falls into 3 categories. So that's tenant-based subsidies, which is the previously known as Section 8, but it's now called the Housing Choice Voucher Program. The conventional public housing, which are owned and managed by the Public Housing Authority and based on the tenant's income, which is generally 33, the rent ends up being about 33% of what their income is, or privately owned building-based subsidies. So if a tenant is part of one of these subsidized housing categories, they can get some additional protections as far as evictions. One of the biggest protections is that there may be a good cause requirement before the termination of the lease. It can't just be for an arbitrary reason or even, just the termination of the tenancy. But conventional public housing and building-based subsidies require an additional separate notice, as well as the option to have an administrative hearing before an individual is evicted. The timing of notice for these depends on the type of program that the individual is being subsidized through. The tenant-based subsidy programs do not require the separate notice or administrative hearing and just follow the regular state laws. And then there are some additional defenses. So if an individual is in subsidized housing, it's important to take an extra look at that, especially because if facing an eviction and subsidized housing can be extremely detrimental for future subsidized housing if there ends up being an eviction. We briefly talked about this before, but for the eviction process, it's a 3-step process. The tenancy must have terminated for some reason, whether that's that the lease ended or that there was a breach of the lease, any of the things we talked about previously. Then the 3-day notice, or in some cases, it might be a 30-day notice, is required. And then once those times have passed, then there can be a filing and service of the eviction complaint. So this was what I was saying with the 30-day. If there's a termination of the month-to-month lease, but there isn't a breach of any of the obligations of the lease, the landlord has to give 30-day notice before the next periodic rental date. And then in the notice of termination for a violation of tenant's obligations that affect the health and safety, 30 days must be given before the termination, and a tenant has the opportunity to cure the issues that might be being caused during that time. And then the landlord carries the burden of showing that the tenant did not cure those. It's also important to note that the 30 days is required. So like, for example, if a landlord wanted to terminate a lease and gave notice on December 14th, the lease for the month to month would not be able to be terminated until the end of January. So it's not based on so if a month has less than 30 days, that changes the notice requirement time. So the notice is always required though, and it must be written, and it must have the notice to leave. It must have the name of the party who will commence the eviction action. And then it also must have specific statutory language in a conspicuous manner if the premises is residential, which there's specific language that must be used, and it must be bigger than other portions, or there's a couple different ways that the court determines if something is conspicuous. Notice must be served 3 days before commencing the eviction action, unless it's the 30-day notice that I had previously discussed. And that can be done through certified mail, personal service, or left at the tenant's place of abode or the rental property. It's important to note that it doesn't count the day of service, and it doesn't account for Saturdays, Sundays, or holidays in between. So an eviction action can be divided into two parts. The first cause of action is to determine if the tenant gets to stay on the property or not. And that is what comes first in an eviction filing. And then there's a second portion that is a portion that's for damages. There doesn't have to be a second portion of the eviction, but if there is, if the landlord's trying to seek money for unpaid rent or property damage, they might have a second cause. That's at a separate time. So the first cause of action is handled first, and then usually, at least in Cleveland, about a month later, the second cause is set. They can both be filed with that original action, or the second cause can be filed later. And for the service of process of the filing of an eviction complaint, it can be by ordinary mail and bailiff, or it can be by certified mail instead of the bailiff. There are some common defenses to eviction actions, and Barb will get more into it with some of the conditions issues, but one big thing is a failure to properly serve the notice that we talked about. If the landlord determines that the reason for the eviction is because of a breach of the health and safety that we talked about, then if the tenant ends up remedying that condition, then within the 30 days, then that's a defense to eviction. If the landlord ends up accepting rent after providing the notice, then that can waive the termination of tenancy and make the notice invalid. Accepting rent for the future can also waive that. If it's a non-material breach of the lease, equity, or if there's unauthorized practice of law, then those can be defenses to keep a tenant from being forced to leave the property. For non-payment of rent offenses, if a landlord has typically accepted late payments, like if the rent's normally due on the first of the month, and they have created a pattern of accepting the rent a week late, 2 weeks late, whatever it might be, then a tenant could present that information and show that they've created this pattern of allowing late payments. If they end up accepting at least some partial payment, it constitutes a renewal of the month-to-month tenancy. If there is a waiver of the non-payment based on them accepting any partial payment, or if the the tenant paid on time, then and the landlord wouldn't accept it for some reason, those can be defenses as well. And then additionally, if a tenant has a counterclaim against the landlord and ends up changing the rent price backwards, that can be a defense as well. Again, something we'll be discussing more later. Security deposits can be returned, or they might be applied by the landlord to unpaid rent, damages to the tenant's violation of the rental agreement, or damages if there was a violation based on the health and safety. A landlord within 30 days after the termination has to return the security deposit and provide the tenant with an itemized list of the expenses that were withheld. It is important to note, though, that the tenant does have to provide a forwarding address when they leave the property. So I'm part of what's called the Right to Counsel team at Legal Aid, and this is something that was passed within the city of Cleveland two Octobers ago in 2019, and became effective in July of last year. And it allows for tenants who are facing eviction that have at least one child in the home and are living at or below 100% of the federal poverty guidelines, which an example being a family of 3 having an income of $21,720 or less is entitled to representation in Cleveland Housing Court. And this was a partnership through the United Way of Cleveland and the Legal Aid Society of Cleveland. And we also help tenants find emergency financial assistance through this program if we're able to as well. If someone wants to access the Right to Counsel program, they can go through any of these ways and pointed out Legal Aid's website. These are specific ways that Right to Counsel can be reached as well. There are no in-person intake hours at this point, so it is through Legal Aid's online or phone intake or through any of these other sources. Also, the Right to Counsel team has attorneys or law students or individuals on each docket screening. So in the actual court hearings every morning or throughout the day, that watch for, and the magistrates allow us to ask if a tenant could qualify, and then we can do screening in the hearings as well. For the legal representation for the Right to Counsel individuals is we work to defend against the eviction, and we facilitate access to the court via technology. So if any of our clients are unable to attend a hearing virtually, we can work with them by either having them come into our offices safely, or we are launching a new program that they will have access to laptops as well. We work to file counterclaims against the landlord if they're appropriate. We seek to repair poor housing conditions at a rental premise if we're able to work with the landlord. We facilitate rent assistance applications, and we provide legal aid social work services for different referrals and different programs internally and externally. Something that is in place right now is called the CDC eviction moratorium. And what that is that the Center for Disease Control issued an order that stopped some evictions to help the spread of COVID. It's currently in effect through May 31st of this year. It could be extended. It was originally set to expire at the end of December, and then has had a couple extensions since then. So what the order does is that a landlord may not take any action to evict certain qualifying individuals from their home or apartments. They do still have an obligation to pay rent going forward, and they must still comply with the lease and all of the local applicable laws. They must qualify for the protection, and in order to do so, they have to read through a list of things that, they had suffered a loss in income, that they've applied for financial assistance and a couple other requirements. And then they must fill out this CDC declaration and serve it on their landlord, or if their landlord has counsel, through the landlord's council. Some of those things that we're talking about, the tenant has to do the following and be able to attest to that they've used their best efforts to get all available government assistance for rent or housing, meet certain income limitations, state that they cannot pay their full rent because of a loss of income. It does not have to be specifically related to COVID. It's just a loss of income or loss of income in the household. The tenant is using their best efforts to make timely partial payments as close to the full payments as their circumstances will allow, and also state that an eviction would make them more likely to be homeless or force them to move into close quarters with other people. Every individual over 18 that lives in the property has to complete one of these as well. The law only protects tenants from eviction for non-payment of rent or other similar housing payments, but tenants still can be evicted for criminal activity, threatening the health or safety of other residents, damage done to the property, violating local health or safety laws, or violating any other lease provision. So it's, if you do any of these things, you could still get evicted from your property, but if it's for non-payment, or there is some courts allow the evictions for non-renewable lease to be covered by the CDC. Some do not. At this point, we are kind of still figuring out what would be applicable there. There is quite a bit of rental assistance available right now to those that are struggling to pay their rent. And this specifically spells out ways that a tenant can apply for different types of funding in the different counties that we serve. All of these resources are also available on Legal Aid's website. 211 is a big resource that can direct you to a lot of these as well. And CHN is a big one in Cleveland that we use to really assist clients in getting funding. That's all that I have, and I'm happy to take any questions.
Great, thank you so much, Bobby. We did have a couple of questions come in. So let me just read these out loud for everybody. The first one was about the 30-day notice and the timing related to that. So does a 30-day notice have to be issued on the 1st of the month or the same date the lease was signed, i.e. the lease started on the 15th? When can a landlord give a 30-day?
Good question. And Barb might be able to better answer, or Hazel might be better to answer that.
I don't mind if you want, Bobby.
Go ahead, jump in.
There are two kinds of 30-day notices. So one has to do with bad conduct, and that one, you know, saying that the tenant is violating health and safety, maybe by not taking the trash out, having, 14 cats and not taking care of them. Those sort of notices can get served any time in the month. The kind of notice that you serve when, somebody said the sound is low here, the kind of notice that gets served to terminate a month-to-month tenancy starts to run concurrent with the rental period. So it can be given any time during the month, but the court will have to decide the period of time for which it runs, and that would be the rental period. So for example, if the rent was paid to cover the 1st of the month to the 31st of the month, you can give the notice anytime up to the 1st, but it doesn't start to run until the 1st, and then it ends 30 days after that.
Thank you. And then another notice question. If a tenant receives a 3-day notice on Friday, is the 3-day time period over on Monday? How do you count the 3 days?
Saturdays, Sundays, and holidays are not.
Oh, Bobby, we're losing your sound.
Oh,
that's better.
Okay. The Saturdays, Sundays, and holidays do not count. So if it was a Friday, then it would be Monday, Tuesday, Wednesday. The third day would be Wednesday, because it's also the day that it's served does not count either.
And so just to be really clear about that, the landlord would have to wait those full 3 days, and the earliest they could file the complaint would be on Thursday. Or could they? Is that correct?
Yes.
That can vary a bit jurisdiction to jurisdiction. So that's definitely how it works in Cleveland. But other courts might decide that the landlord can count the weekend. So it's helpful to know in your particular city what the rule is.
Great. So I'm just going to kind of keep scrolling through here. With the Metropolitan Housing Authority in any county can give tenants a 3-day notice for not cleaning their apartment. Or will they come back and check the apartment? What is their definition of clean?
I don't know if Barb or Hazel knows more specifics about this. I don't know if it says maybe somewhere in the lease agreement or there is a definition of what clean is. Not sure.
So usually when a housing authority gives a notice related to like a health or health or safety violation or something like that, which is what this would be considered. We see it in like the housekeeping cases where, you know, the housing authority thinks that the tenant isn't maintaining the property to their standards for housekeeping. And usually there is a period to cure the defect. So they should be issuing the notice, giving the tenant an opportunity to address the housekeeping issue, and then coming back and potentially giving the tenant an opportunity to address it with the management. In terms of a definition of clean, I don't know that there is one in particular. At least I haven't seen one. And some you know, less about the housing authorities, more with the subsidized housing landlords. So like project-based Section 8, where they're owned privately but subsidized, those are the cases we see more regularly where, you know, one particular property manager comes in and decides, well, this person's standard of, you know, housekeeping isn't up to par with what I'm seeing or what I'm expecting. So it varies by management company and by manager, but the tenants should be given an opportunity to address the issue and correct it.
Could I add something? I was a magistrate at the Cleveland Housing Court for a long time, and the housekeeping cases are some of the most difficult, just because most difficult to decide, because every manager, like Hazel says, has their own view of what clean enough is. And so what the court tended to look at was, does this really affect health and safety, or is this clutter? You know, is the person taking care of things like dishes and dirty clothes? Is it likely to cause rats or mice or bed bugs or roaches? Really trying to focus on the health and safety and not just clutter. And for lower income people, you've got to bear in mind too that they may not have dressers for everybody in the house, so that clothes may be in a laundry basket. Dishes may be kept in a box, you know, that they may not have all the amenities. And so I think it's important to point some of that out when you're trying to defend those cases and say, my client isn't, you know, storing their clothes in a basket by choice as much as they can't afford some of the things that other people might have.
Thanks, Barb. Jumping around, I'm gonna go back to Bobby, the late fees conversation, and just a question to you to please summarize your explanation again about the law related to late fees.
Yeah, so if the rent is over $500, the maximum late fee is 5%. So they can't charge more than 5% of what the total rent is for a late fee. If the monthly rent is less than $500, the maximum fee is $25.
You faded again. You said the maximum is $25 if the rent is under 500?
Yes.
Okay.
And just to clarify, that is the law for Cleveland. It is not a statewide law. So different jurisdictions have different ordinances that have been enacted. So And sometimes even, even if there isn't a specific law in that particular jurisdiction, courts will adapt that similar standard. So it just depends. But there is case law, and Barb, maybe you can speak to this off the top of your head, but there is case law that talks about late fees have to be connected to, they can't be like liquidated damages or something.
Some jurisdictions won't even allow a late fee routinely unless a landlord can show that they have an expense related to that. So it can't just be a punishment, but if a landlord has, for example, if it makes their mortgage payment late and they suffer a $30 fee, places other than Cleveland may allow that because it's related to the landlord's expense.
Great, and hopefully this is a quick one. The CDC declaration, is it required for every adult in the property or every adult on the lease?
Every adult in the property.
Great. And then a slightly more complicated scenario. If a tenant is on a lease jointly with their significant other, but starts to experience domestic violence threats or violence from that significant other, can the lease be broken to allow the person suffering the abuse, the tenant suffering the abuse, relief from their situation?
So we got this question yesterday and we discussed it a little this morning. Barb, if you had a very thoughtful answer to this, if you want to.
Right, and either you or Hazel may want to talk a little bit more about the legal aspect of it too. I think there are some questions for which a legal answer makes sense, and there are some questions for which a practical answer makes sense. And so if my client is suffering from domestic abuse, I'm not going to encourage them to stay just to avoid having to pay the extra rent under the lease. I think there are some arguments to be made if you give the landlord notice that your client is unable to fulfill the terms of the lease. But really, as a practical matter, I wouldn't encourage them to stay, and I would try to deal with the court if the landlord sues for the balance of the rent. The other thing is you may be able to get some cooperation from the landlord, for example, to terminate the tenancy for both, but then allow the victim to move back in. But as a practical matter, I wouldn't ever counsel them to try to stay to avoid breaking a lease. Hazel, did you want to add something to that?
No, I mean, I think the first approach is always going to be to try to get the landlord. So there could potentially be an obligation that they share, that both parties share. And there could be mechanisms, like legal mechanisms, to sever the lease or to rescind a section of the lease. But the first step is always going to be to try to get the landlord to agree to that. And then subsequent, if they don't, have the court make a finding. But yeah, I agree with Barbara that the most practical way is to tell the person who's the victim to leave if they need to.
Thank you, guys. Regarding drug activity, can you expand on that issue? Is it suspected or does it need to be proven? And if so, how? So how much evidence of the drug activity does a landlord need before they start the eviction process against a tenant, is how I understand that question.
I have a gut instinct answer, but I don't know if Barbara Hazel might have a more clear answer on that.
The statute, I will say that I think we're seeing fewer and fewer evictions for actual drug activity. It's more like, the disruption of the neighbor's quiet enjoyment because of the amount of the traffic or it's damage to property. You don't see a lot of landlords filing for drug activity. The state law puts some fairly high burdens on a landlord who's trying to evict for drug activity. Off the top of my head, there has to be, a search warrant executed at the property naming the substance that they're searching for and the tenant as the person. It has to be properly executed. They have to test for the drugs. So the bar for evicting for actual drug activity is pretty high. I think landlords are more likely to evict based on the noise and the commotion and the disturbance of neighbors than actual drug activity. Hazel or Bobby, is that what you're seeing as well?
I haven't had much experience with it at all, but I think, yeah, that it's been more clear of like if there's complaints from others that those are, can be neighbors brought in and things like that to discuss that more than the drug activity level.
And I want to add one thing with regards to the criminal activity cases is that they are tricky to maneuver only because if there really is some sort of criminal activity that happened, that tenant might not be able to take and testify in their case, in their eviction case, because the criminal case is pending. And so just really have to be mindful of that, and those are the type of cases that we take on, and you should be referring them to us.
Thank you all. We just have 2 more questions, and that will probably put us right at about our break time. So the next one is, as an APS worker, we get many calls on people that elderly let move in with them without a lease and then want them out. If there is no lease, what is the process? So I'm thinking of a scenario where an older adult maybe had surgery, maybe they need somebody to move in for a period of time to help with tasks around the house or caregiving, but doesn't want them permanently there, but then that helping person won't leave. Is there recourse for that situation?
And maybe just for me to be clear, the landlord wants them out or the tenant wants this other person out?
I think the question is where the tenant wants the other person out, but the person who asked can clarify in the chat if I misinterpreted. But I'm thinking this is where the tenant who maybe initially invited them in to do that helping role has now decided that's over and they want them to move out.
I have not had this happen before.
I think this is similar to cases where one tenant lets a significant other move in and then things go bad and they want them out. So it's a tenant versus, trying to get an occupant out. And I think, from jurisdiction to jurisdiction, that will vary. Sometimes the police will get involved, not in Cleveland, but in some places the police can be called. And you can say, I want this person out. This is my home. They're not a tenant. I want them out. And so it's probably worth seeing if the police are willing to get involved. The tenant could evict the person who's staying with them with no agreement. That's a little, that process takes a little time. And hopefully the tenant can either stay somewhere else temporarily or has some support in doing that, because they're in the weird position of both being in the space for a number of weeks. There also may be protective orders that are available if there is a threat.
We get told a lot by the police that go out on the visits that if they've been there for 30 days, they have to file for an eviction. So this person may even own their own home and they let somebody stay with them and then they don't want to leave. So, or they may have, abused them, and there's still no protective order that we can do to protect these people from their abuser. They have to file for a protective order with the local sheriff's department, but that still doesn't get them off the property.
Right, and so an eviction will take a minute of time, and that's why I say people will need support in trying to do that. That's not, the 30 days that the police are citing is not in any of the Ohio Revised Code. It's not a magic number. I suspect, I'm not positive, but I suspect it's the police policy more than the law. And you can appreciate they don't want to get into the middle of domestic disputes and make mistakes, but it's frustrating sometimes when people are in actual danger and the police say, well, this is a civil matter. Hazel, do you have more thoughts about this?
And if Hazel's jumping in, I want to add a twist from our chat. In the same scenario, does the landlord have any additional recourse if it's not a homeowner, which was the scenario just mentioned, but let's assume there is a rental property and the same situation, can the landlord offer some additional help to that tenant who's trying to get rid of the occupant potentially?
I mean, a landlord could file an eviction against the occupant. They could also file an eviction potentially against the tenant for having an unauthorized occupant.
And I've seen landlords who are willing to file that and then say to the tenant, I'm going to go through the eviction, move everybody out, and then I'll let you move back in with a new rental agreement with you. The Cleveland court won't split the occupants of a house for an eviction. They won't say you can evict 2 people, but not the other 2. And there are oddly practical reasons for that. But if the landlord is sympathetic and cooperative and has a good relationship with the tenant, the landlord can actually help get the third party out of the unit and then just set up a new rental agreement with the tenant.
All right, last question. Can a landlord enter a residence against the wishes of the tenant once a 24-hour notice is given and the time has passed? What happens if the tenant physically won't let the landlord in?
If the 24 hours notice was accurately given, even if the tenant doesn't want them, it is the landlord's. It is their right to enter their property if proper notice is given. If they physically won't let them in, I mean, that's definitely grounds for an eviction. In the actual moment, I would just maybe assume that they could call the police, but they do have the right, once they have 24-hour notice, to come into the property, even if the tenant doesn't want that.
And just to clarify, all the landlord has to do is post the notice, let the tenant know that they are intending to come in on a date certain of some sort, you know, that they're going to come in and inspect the unit. We see cases sometimes where landlords are abusing that behavior. And so that can also be grounds, like a tenant can have a case against the landlord for unauthorized entry or into the unit. So it goes both ways. The landlord has a right, but so does the tenant. That's it. That should not be violated by the landlord either. And I see Emily, I think had her hand up.
Oh, thanks for noticing. Go ahead, please.
Thank you. I was just wondering if the landlord goes through the eviction process and cooperates, will that eviction show up on the person's record or credit report that wanted that other person out? It will.
Yeah, that's a good question. Yeah, it would.
So it wouldn't really benefit them to go through the landlord process because that eviction will show up on their credit report.
So
Right.
much of it will depend on the jurisdiction that you're in. So Cleveland does have a rule that allows for the sealing of eviction records under certain circumstances. So that might be a circumstance where the tenant might be able to avail themselves of that opportunity. There are other courts, not just Cleveland. I think Garfield Heights has adopted a rule and a couple of other jurisdictions. So depending on where you're at. The other thing is that a motion to seal the record can be filed under the courts, just all courts inherent authority to do it. So you could do it even if there isn't a rule. You just have to make your case as to why it should be sealed.
Just real quick, if I could add something about records, eviction records. What a lot of tenants don't understand is that as soon as the case is filed, it's on their record because landlord or somebody might, look at loaning the money, can just look and see that there's been a court filing. Most people who are looking are just looking at whether there was a filing. It's a fairly rare landlord who will look all the way to the end and see how the case turned out. And so we can get records sealed in Cleveland and in other places, but tenants should understand that as soon as it's filed, it's going to get picked up by credit bureaus and other places.
Well, thank you all so much. It's 2:02 and I want folks to have a chance to get a break, and we have lots more to talk about for the rest of the afternoon. So there'll certainly be time for additional questions. I am going to invite anybody who wants to turn off your screen to do that and step away. Remember, if you're here for continuing education credits, please don't disconnect from the Zoom. We want to give you the full credit you're entitled to, but we will resume the presentation at 2:15. So thank you all. Great, welcome back, everyone. I am pleased to introduce our colleague, Barbara Reitzloff, who is going to get started with a conversation about housing conditions issues. So Barb, take it away. You are muted though.
That half hour will go really fast if no one can hear me. I thank you, Anne. I appreciate the chance to get to talk about conditions issues. I'm an attorney with the Legal Aid Society. I'm also in the housing group and the Right to Counsel group. And so a lot of our time is focused on evictions and eviction defense. In looking at conditions issues, a couple things came to mind. We sort of need to shift our mindset from the eviction process. The eviction process is very defined. There are notices that require, of different lengths that are required for different things. They're all set out in the statute. There have to be certain words in the notices, and then the case is filed in court and there's a decision, and there's a very specific process. Conditions issues are more like problems and not necessarily cases. They start out as problems that people come to us for some help with. So there are places where there are different options and decisions to be made, and we'll talk about what those might be. I also think evictions kind of burst into a tenant's life like an explosion and turn everything upside down for a relatively short period of time, but conditions issues are more like a slow burn or a toothache that just won't go away. And so the conditions issues can last for weeks or months or years. They deprive tenants of the value of the property. They disrupt their lives, sometimes in really quick ways, like a termination of heat or no water, but sometimes it's a persistent leak, or it's a draft because the window is broken, or it's outlets that just don't work over a long period of time. And by the time they get to a case, everybody's angry and it's worked up to the explosion level and it's harder to deal with. So we'll talk about ways to address the issues that are low cost and fairly early. And then as it escalates and gets into cases, we can talk about what to do with that. And then I'll mention a few things that I think tenants can do right from the start to try to protect themselves from these condition issues. So the four things that I'll try to look at in the next half hour: figuring out whether the bad condition is something the landlord is responsible for repairing. How does the rent deposit process work? Can the tenant do anything other than deposit rent if the landlord won't make repairs? And then what if the tenant's already in court? And we'll talk about how conditions issues work themselves into cases that are already pending. So Bobby talked a bit about the Ohio Landlord Tenant Act. There are two parts of it. She mentioned Chapter 5321. That's really landlords and tenants and their duties to each other. What can be in leases, what they're not allowed to do. And then 1923 is the eviction part, the process for the eviction. So I'll be talking more about the 5321 section, which, just so when you see those numbers, that's referring to the Ohio Revised Code. That applies to all tenants in the state, all residential tenants in the state, except in manufactured homes. And manufactured homes have their own section, and some of the provisions are similar, but they're different enough that we don't have time to do all the manufactured home stuff today. And 5321 really is just for residential tenants. So if you have clients who have companies and businesses and they have those issues, those folks really should talk to an attorney because most of this will not apply. It's not just state law. The state law applies to all the tenants. Then there will be local ordinances. In Cleveland, we have an ordinance just about landlords and tenants. It's Cleveland Codified Ordinance 375. It just applies to the tenants in that particular city. And then finally, the lease or the rental agreement may also address repair obligations, the obligations that people have to fix things, and that just applies to the parties in the agreement. And Bobby talked about this specifically 5320-104, that part of the Landlord Tenant Act tells landlords what their obligations are. And some of the language is a bit lawyery and some of it's a bit thick. I tried to, you see, I wasn't able to take all of it out, but I was able to sort of narrow it down a little bit. Landlords have to keep the furnaces in good working order. The roofs have to be solid, so does the exterior. There shouldn't be peeling paint on the outside. Most of the ordinances and the provisions refer to it as weather tight. There shouldn't be gaps in the foundation where animals can come in. Landlords should keep the property free from infestations, mice, rats, roaches. We've had a lot of raccoons lately getting into people's houses. The animals just get bigger and bigger, but landlords should be taking measures to keep that from happening. Sinks, showers, tubs, plumbing should work with no leaks. Electrical outlets, switches, fixtures should work. There shouldn't be shorts or sparks or just dead outlets and dead switches. The ceilings and the walls in the house should be solid and free from leaks. We see a lot of ceiling leaks through roofs. Landlords should be addressing that quickly, or really ideally performing enough maintenance to not have that happen at all. Exterior doors should close and lock. We've had a lot of tenants lately who say they don't have keys. Tenants should have generally 2 means in and out, but at the very least their doors should lock and they should have keys. And porches and steps should be solid. There shouldn't be holes. There should be steps when they're necessary. Hazel, you can flip that one. Thank you. And so tenants have a corresponding set of duties. And they're the things that you would expect if you think about the fact that the tenant is living in somebody else's house. They need to keep it clean. They need to dispose of the trash properly. They need to do what's reasonable to discourage mice and raccoons and roaches and things. So they need to not leave food out, keep the dishes under control. They have to be careful and use sinks and showers and tubs for the purpose that they're intended for. Use them properly. Don't have people break sinks because they stood up on them. Use the fixtures and the appliances for what they're intended. The same with the electrical service. Sometimes tenants will use an excessive amount of electrical cords or extension cords, and they might decide to help their neighbor by letting them use an extension cord to run a second apartment off of it. Basically, you just need to be careful with those and use them properly. Appliances, if the landlord provides them, have to be used for their intended purpose. And landlords should be notifying tenants when repairs are needed. So most of the maintenance is left to the landlord. The tenant's supposed to use things carefully and keep them clean. If a tenant breaks something, a landlord may have a duty to repair it, but bear in mind the landlord may be able to pass those costs on to the tenant. So if a tenant breaks a window, the landlord can't just say, "Oh, window's broken, you broke it, I'm not fixing it." The landlord needs to repair it, but also then can pass those costs on to the tenant. That's good, Hazel. As I mentioned, leases, you can go to the next one. Leases and local ordinances can add, whoa, back one. Okay, leases and local ordinances do add some requirements. Some examples of that would be in Cleveland, the codified ordinance 371.11 tells you exactly how much heat a landlord has to supply. Enough to keep an inside temperature of 70 degrees when the outside temperature falls below 50. And so we've had a bunch of these cases lately. And sometimes it's not that the tenant has no heat, it's that the tenant is saying the heat is too weak to keep the apartment, above 60. And that's still a violation if there's inadequate heat. And the parties lease, as I mentioned, can also add some other requirements for landlord maintenance. For example, if the landlord gives the tenant permission to use the laundry facilities, then the landlord needs to keep those appliances in good working order. The tenant needs to use them properly, but the landlord should repair them if they break. That becomes a common area that the landlord should keep clean. You know, if there's a flood in the basement and the tenant can't use the laundry facilities, the landlord has a duty to address that. The party's lease may require the tenant to pay for water. We see lots of arguments about water, but the landlord has to ensure that the water pipes are working and that the water system is working and the landlord is not impeding the supply of water in any way. There are a couple of, so most of that I think is intuitive. You know, landlords do the kind of maintenance that people do on their houses. Tenants use the kind of care that they would use if they were a guest in somebody's house. There are a couple of issues that I'm not going to spend a ton of time on, but I think it's worth mentioning with respect to rent deposit. So lead. I think we all know at this point that lead paint and dust can poison children. The symptoms may not come up right away. Parents sometimes find out when the children's blood levels have been tested. Many of our lower income tenants tend to be very mobile for lots of reasons. So they may have lived in a number of units. I really, in lead cases, suggest that you get tenants to attorneys and get them some legal advice as soon as they know that a lead poisoning issue exists. There are issues about proof and preserving proof. There are issues about parents having claims that get raised sooner and children's claims which last longer. The children may have claims for personal injury. Just personally, I would encourage tenants with lead poisoned children to get legal advice as early as possible. So while other people might want to pay their rent into court and see how that works out, I think lead is just way too complicated and the stakes are way too high. I would encourage them to get some legal advice as soon as possible. Then there are also bed bugs and pests. So causation is also an issue in those cases, especially with bed bugs. Landlords will say there were no bed bugs when the tenant moved in, and the tenant will say, I didn't bring bed bugs. The court in those circumstances will look at who's responsible for those issues. Doesn't mean the landlord doesn't need to address them, but the tenant may be held liable for the cost. And so with pests in particular, if you can have landlords and tenants, if you can encourage them to talk and reach compromises, I think those are useful in those cases too. Doesn't mean you shouldn't rent deposit in those circumstances, but you know, as somebody mentioned, not wanting a landlord to exterminate for bed bugs because of the chemical used. That's where if you can have a discussion between the landlord and the tenant, you'll get further than trying to file things in court and having arguments before the court. One of the disadvantages of getting disputes before the court is that often the court has to decide one party's right and one party's wrong, and there's not a lot of room for the middle. If your court offers mediation, or if your city talks about, if your city offers mediation or their mediation programs, they may be useful. I also wanted to talk about access and notice, because I think there were some questions about that. Access and notice issues go hand in hand with repair issues. A landlord has to give reasonable notice to the tenant if they want to come in the property. Reasonable notice is usually 24 hours unless it's an emergency. You know, if the downstairs tenant reports to the landlord that the upstairs bathtub has overflowed and is leaking into their house, the landlord's going to be able to go in without notice, or with very short notice, like knock on the door kind of notice. Landlords are only supposed to enter at reasonable times. Again, that's an emergency issue, but other than that, landlords shouldn't be coming over at 10 at night. And landlords are not allowed to abuse the right to access. So I had a case recently where a landlord was giving notice to the tenant every day that they were coming in to make repairs, when in fact they would give the notice, show up, look around and leave. give the notice for the next day, show up, look around and leave. And so that had the effect of abusing the right to access and just really being a way to try to harass the tenant. Tenants have to allow landlords reasonable access to the property, and tenants can't require the landlord only to come when the tenant's home. And this is one that I think tenants have a real difficult time with. I was a tenant for a very long time. I can appreciate, I didn't really want the landlord wandering around my apartment when I wasn't there. But there's nothing that gives tenants the right to say, you can't come in unless I'm there. That's a spot where, again, having a good relationship as a landlord and a tenant really pays off. And that's something I'll mention at a bunch of different points, but when I have had the chance to talk with new landlords or to talk with tenants who are new tenants in a property, I always encourage them to try to work on a good relationship right from the start. And I can appreciate that sometimes tenants feel like they're one down in the relationship. And I'm not encouraging them to be nice to their landlords because I believe that they're one down. I'm encouraging them to try to have a good relationship with their landlord because it helps the tenants throughout the time. When everybody's happy at the beginning and people are getting money and it's all new and fresh, those are the times to work on developing good relationships so that later on when your landlord wants to come in and you've got to be at work, but if they came the next day, you could be there. You may be in a position to pick up the phone and resolve some things because you've worked on a good relationship before the problem started. It's a little preachy, but it's something I do recommend as you think about that early on, how to keep the relationship good when you can, because it will benefit the tenants as time goes on and when things get rough. Also, keys. I thought this was interesting when I first learned it. Unless the party's lease says otherwise, a landlord's not entitled to a pass key or a key to the tenant's unit. But if there's an emergency and the tenant isn't home and the landlord has to break in, the tenant may have to reimburse for that cost. So that if you have issues or concerns about a landlord entering repeatedly, they're not entitled legally to a key. You've just got to have somebody there to let them in. So those are access issues. So if we figured out that a landlord is required to make some repairs and they're not doing it, what are the tenant's options? Tenant has a lot of choices. They can rent deposit. Sometimes it's called rent escrow. They can file a complaint with the court. They can work within an existing court case. They can call city inspectors if they're subsidized tenants through the Section 8 Housing Choice Voucher Program. They can prevail upon CMHA to do an inspection. They can organize with other tenants. Some of these options are more expensive than others. Some of them are more effective than others, and we'll talk about each of them as we go. This again is sort of a practical, check the time here. This is again is sort of a practical slide. You'll see there's no legal numbers or sites in it. For a tenant to get a landlord to make repairs, no matter what option they choose, the preparation, the prep work is really important. By the time we see a lot of folks, things have gone wrong, records haven't been kept, and we can only work with the evidence we have. So tenants who are starting to have some trouble with their landlord, or even before that, just tenants period, can do some things to keep records and document things so that they have an easier time if problems arise. Maintain a decent relationship with the landlord. Notify the landlord promptly when repairs are needed. So, if a tenant is paying their rent, they can put a note in with the rent. By the way, I noticed that the bathroom sink is dripping. Could you please take a look at that? Put it in with the rent because if the landlord gets the rent, they got the note. Keep a copy of the note, but start when it's small, because if you don't and the landlord doesn't address it, eventually you're really angry because the water is pouring and maybe you're paying for the water. Start small, Landlords are also more likely to approach it rationally and helpfully when it's a small issue. Follow up if the issues aren't addressed, document the conditions. This is where, it's not a bad idea for a tenant to get a notebook or a folder and just keep it with every paper related to the landlord, so that when they find themselves in court or from, trying to take action on this, everything's in one place. Take pictures, keep reports if you get anything from the city, make notes. Every time you make a repair request, take a copy of it or print out the text. With respect to text, remember that your text could end up in court. This is sort of, again, a holdover from my days of being at the court. People get angry and they speak to each other in astonishing ways, using some words I've never even heard before. And those words may be read out in the courtroom, and the tenant wants to be the one who kept it professional and calm and reasonable. So remember, if you're sending letters or notices or talking to somebody who's going to do that, remind them to keep to the business and avoid the name calling. Take photographs of any bad conditions. The picture's worth 1,000 words. When my client tells me there's a hole in their bathroom ceiling, in my mind, that could be anywhere from 4 inches across to half the ceiling is gone. And I've seen some breathtaking photos from clients. And the court will react the same way if they see the photographs. Also, if the tenant loses property, if the ceiling falls and their mattress is ruined, take a picture before they clean it up. If they can take a picture of the ceiling on the bed. Take a picture of the dining room table that got broken or the kitchen table when the cabinet fell off the wall. Keep receipts for lost items for any expenses. Let's say the heat goes out and the landlord's not coming around to making the repairs and the tenant buys a space heater. Keep a copy of the receipt, take a picture of the space heater, put them all in a big folder. It's much easier to sort it out in a folder than to race around your house to try to find everything. And then keep a record of all the repair attempts that the landlord makes. If you can, I know landlords don't like to divulge ahead of time sometimes the name of the person coming, but if you can, in casual conversation, find out who it is. Oh, your name's Bob. Thanks, Bob, for coming out. And write down Bob came on Tuesday at 2, and this is what happened. All that will pay off later on, so that when you come to see us or somebody else, you've got all your records. Landlords will keep their records. The best landlords treat it as a business, and they have their records. The tenants have to, in some respects, treat this as a business relationship too. So, tenant's been trying to work it out with the landlord. It's just not working. Tenant's ready to deposit their rent with the court. First thing you have to look, the tenant, and Bobby mentioned this before, the tenant can't rent deposit if the landlord owns 3 or fewer rental units and notifies the tenant in writing of this at the time of the move-in. In 32 years of practice, I've never seen a landlord do this, but it still could happen. A landlord could still notify the tenant, and that exempts them from the rent deposit process. So the rent deposit process is not just paying the rent into court. They're actually, the statute does give a bunch of different things the tenant can do in the context of rent depositing. They can pay their rent into the court. They can file a complaint asking to have the rent reduced, asking the landlord to be ordered to make repairs, and asking that some of the rent be released to the tenant to make repairs. They can also terminate their rental agreement. But first we'll talk about just the actual deposit of rent. Hazel. There we go. This is the only process for a legal rent deposit or a rent escrow. There are some states, where I come from in Michigan, it's a repair and deduct state. So a tenant can make a repair and deduct it from the rent. Ohio is not a repair and deduct state. So a tenant, this is how you do a legal rent deposit. A tenant can't stop paying rent to get the landlord's attention. They can't withhold the rent by keeping it in the bank. A lot of tenants figure they're escrowing it with their bank, but it's not protecting them legally from an eviction for non-payment. And again, they can't make the repairs and deduct the cost from the rent. Step one, is the tenant eligible to rent deposit? Did they get that notice saying the landlord owns 3 or few units when they first moved in? If they got that notice, they can't use the process. Is the tenant behind in the rent? If they are, they can't use the rent deposit process. And that's a shame, but it's the truth. And if they start to use the rent deposit process and they're behind in their rent, they can be evicted for non-payment, and the rent will be tied up with the court. So it'll make it very hard to move. So tenants should be current when they pay their rent, when they deposit their rent. First step, in that first step, there's make a list to the landlord listing everything that needs repair, and be sure that that list is complete, because the court in later decisions and later steps will only consider what's on the list. So if I don't have heat or hot water or water at all, and I only write water, the court's not going to look at the other 2 things, and the tenant may have to give a new notice and wait another month to deposit. So make sure everything is on the list. Better to overlist things than underlist things and let the court sort it out. And then that notice gets sent or delivered to the person or the place where the rent is normally paid. Ann says talk faster. Okay. Next. Landlord has a reasonable time to make repairs, up to 30 days. It's shorter for issues like heat and water. If the landlord doesn't make the repairs within a reasonable time, the tenant can deposit the rent with the court in the city in which the tenant lives. So they have to be current, the rent has to be deposited full and on time, and the tenant should bring the repair list, the landlord's name and address, and the property address to court. Rent depositing, just the act of depositing your rent with the court, it's good for tenants because it's relatively simple. Tenants don't need an attorney. It's a low-cost option. They don't have to pay a filing fee. The court may take out 1% of the rent when the case is being resolved. That usually can be negotiated between the parties. And just depositing the rent is a pretty good place to start if there are a number of non-critical repairs that are needed. Things that mitigate against depositing rent. The process is not as good if the landlord has a lot of resources and doesn't really need the rent, because it just relies on getting the landlord's attention. It takes time. It's not as helpful for cases like no heat, no water, because of the time it takes. It also ties up the tenant's rent in court. So tenants should bear that in mind. They're investing in staying at the property if they start to pay their rent into the court. After the initial deposit, tenants can keep depositing rent for as long as necessary. There recently was a case in the court where the tenant paid in for 10 years and the landlord did nothing to get the money out. Most cases don't work like that, though. Either tenants get tired of waiting or landlords do the repairs. But it does go on for as long as necessary with the tenant just depositing the rent into the court. Some courts will schedule a mediation to see if the parties can work it out. Cleveland does that. The tenants can release the rent from on deposit when the repairs are made, or the parties could agree to split the rent and release it from the court. The tenant retains a little bit of control over the rent when it's on deposit. They can't release the rent to themselves, but they can release the rent to the landlord, or the parties can make an agreement about how to release it. The tenants have to pay the rent into court or pay the landlord to avoid being evicted for non-payment of rent. So if the rent deposit doesn't produce repairs, the tenant, again in the rent deposit process, can file a complaint with the court asking for a reduction in rent till the repairs are made. They can ask for the landlord to be ordered to make the repairs, or to release some of the money for the tenant to make the repairs. And that does happen in some cases. Say a landlord's not repairing a furnace. The tenant can submit an estimate and file a motion with the court and ask the court to release the money to the contractor to make the repairs. You don't technically, these are sometimes called motions to compel or complaints to compel repairs. The tenant doesn't technically need an attorney, but the landlord may get one. There's a filing fee. Sometimes a poverty affidavit can waive prepayment of the filing fee. Getting service on a landlord, finding a good address for a rental company can be difficult. There are forms available for the complaint on the Cleveland Housing Court website. Those forms should work in places other than Cleveland. So just because they're on that court's website, the complaint for repair should work anywhere. It may require multiple trips to the court for mediations or hearings, but this is kind of the next step to elevate the rent deposit process. If it's not working, a couple months get deposited in, then the tenant can file something, say, look, court, the landlord's not budging on this. Either let me make the repairs, tell the landlord to make the repairs, and reduce my rent until the repairs are made. Hazel. As a part of the rent deposit process, so the tenant's paying rent into court, the repairs aren't getting made, the tenant can also terminate their rental agreement. So if they have a 1-year lease and they've paid rent into court for months, 3, 4, and 5, and they just want to move, the tenant can terminate the rental agreement without any court process or approval. And that's good and bad. I mean, it's a little bit riskier because the court's not giving permission for the rental agreement to be terminated. The tenant is taking that action and may need to defend it later if the landlord tries to sue them for the balance of the rent. So documentation that we talked about before, the pictures and the attempts to get things done are really important in the event the landlord tries to sue for the balance of rent due under the lease. Obviously, the tenant won't need an attorney. They just say, I'm moving out, put the reason they're moving out in writing. I've been depositing rent for months 4, 5, and 6. You've done no repairs. At the end of month 7, I'm gone. And the way the landlord can contest that is to sue for the balance of the lease later. So if a tenant wants to, they really need their documentation in place. Whew. Okay, so that's the rent deposit process. Housing condition issues do come up in eviction cases. It's obviously not the best place to be raising them. I mean, if you can avoid finding yourself defending against an eviction, that's the best thing. But the conditions issues, 3/4 of our clients that we interview have some complaints about the condition of the property. And while it's not optimum to be raising them in the eviction case, sometimes that's what happens. Bad conditions don't give a tenant a defense to an eviction claim in general. There are a couple of exceptions. In a non-payment case, if the tenant has all the back rent, there's a little provision in the law that allows them to raise the conditions of the property, pay all their back rent into the court, and then the court kind of balances things out and says, on balance, you're entitled to some of that rent back and you get to stay at the property. The disadvantage of that is it ties tenants' rent up in court. Often tenants don't want to put their rent into court, understandably, but it is a provision that attorneys can use and that tenants can use in non-payment cases. You also can see, Bobby mentioned that a landlord can't evict a tenant in retaliation for complaints. If the landlord, for example, tries to terminate a month-to-month tenancy, the tenant's not behind in the rent, but mysteriously this came about when the tenant, just after the tenant made complaints about the condition of the property to the landlord or to city inspectors, the tenant can raise those conditions and the complaints to show retaliation. And in some circumstances, eviction is considered equitable, which means just that the court can look at whether everybody is coming to it with what's called clean hands. Is everybody being fair? And have they done the right things has the landlord done the right things when they brought the case? So you could argue that a landlord who, for example, cuts off the heat to try to force a tenant out, files an eviction, then terminates the utilities, that landlord may have unclean hands and the eviction could be denied on that basis. Bad conditions also can give a tenant a defense and a counterclaim to claims for back rent. Tenants can sue for lost property and expenses for a reduction in value of the property, for inconvenience and disruption of their living routine. That can help reduce the amount of back rent that a tenant may owe. It may give them some room to negotiate. Tenants can also raise conditions issues when those conditions come up during the eviction case. Like I've said, heat shut off, water, we've seen those cases. You can ask the court to deny the eviction. Usually the court won't deny it, but will require the landlord to restore those utilities before the eviction goes forward. Finally, the court can ask, there's something called a motion to prohibit re-rental. The court can ask, the tenant can ask the court to order an inspection of the property by the city and can order the conditions corrected if the tenant is staying, or order that the landlord prohibit re-rental of the property until the repairs are made if the tenant is evicted. It's something we've started using more and more at Legal Aid. It's a good way to try to address the overall condition of rental properties in the city. These are issues we talked about. Try to keep a good relationship, be organized, address issues early, call us for help. I think that's it. Sorry, Ann, tried to talk really fast.
You did great, Barb. No worries. It's a lot to cover. Thank you so much. So I'm going to take us through some of the questions. Others can add to the chat if you have something else you want to ask about. One of the first questions that was raised, actually, I think I'm going to hold because it relates to occupancy and family members. And I think that might get covered in our next session. So we will circle back on that. And certainly you can reiterate your question if we don't cover it in the next segment. Can a landlord give access to a tenant's unit to police, EMS, etc., if there's a reason to believe there has been a crime committed or for a safety concern?
Wow, that's a great question. Certainly if they believe that there's an emergency. So, you know, if police are in pursuit of somebody, they go into the unit to try to, oh, this is tough. Hazel, do you have thoughts about this? I mean, I think if they think somebody's in danger, the landlord can give the police access, EMS. I'm less certain about executing a search warrant.
Yeah, I'm not sure about the warrant, but definitely if it rises to the level of an emergency, they can let them in.
It's like the flooding bathtub. If they haven't heard from the tenant, they think they're passed out in there, the landlord can give access.
Right. If a tenant cannot live in the unit temporarily due to a maintenance repair that needs to be made, is the landlord responsible for paying for a hotel for them to stay at while the repair is made?
I would argue that they are, unless the tenant caused the conditions, or finding somewhere, or somehow making other arrangements for a place for them to stay. Like if the landlord has another unit. Sometimes, I know, Hazel, you've seen that come up with lead cases where if there's going to be a prolonged period of abatement, the landlord's got to find some place for the tenant to be, not necessarily a hotel. They could have another unit.
You see it come up in, sorry, I was just going to say, you see it come up in fire cases as well, where the unit is uninhabitable because of a fire. And it comes down to whether the tenant played a role in that fire in some way.
And that was exactly the follow-up, Hazel. So the question was, are there specific responsibilities in the event of a fire in the unit? But it sounds like you covered that. Another question, are you better off texting for proof, date stamp that you're trying to get the landlord to fix an item that needs repaired? I assume this question is better off texting so that you have the back and forth documented as opposed to writing a handwritten note or typed up note that you then deliver. That's how I'm interpreting the question, but please elaborate in the chat or unmute yourself if I'm misinterpreting your question.
I guess I think delivering it with the rent is always a good idea, because once they've cashed the rent check or, received the rent, you've got your proof. I think anything that you can get the landlord to respond to, I think emails, texts, communication is changing. That's changing how we do some of these things. But if you can get the landlord to respond, certainly you can print out the text messages and use those as evidence.
Great, thank you. What if the landlord passes away and you are not sure who legally owns the property? Should the tenant keep paying family members or wait until the court gets involved?
Hazel, Bobby, take that one. That's not a conditions question.
I mean, technically, if the owner passed away and it's part of the estate, those cases are so complicated. You know, so there's a variant scenario. So there's like the scenario where a new owner somebody else buys the property, and in those instances, the new owner takes subject to the lease. So if there was a lease agreement, the new owner would take it subject to that. With the estate cases, that's not always true, because the case might have, or the property might have to go through probate or through some sort of estate process in order to determine who has ownership of it. But if there is I guess if there's a direct person that you know the tenant has had a relationship with, and that's who they should be paying their rent, as long as there is a record of the rent payments and some sort of communication that they are collecting it on behalf of that estate, I would feel comfortable in that scenario. Otherwise, the tenant should just hang on to it and wait until they get taken to eviction court. And at that point, the court would sort it out.
Would getting a really detailed receipt from the person the tenant gives the money to be helpful in that situation? So a receipt that says, you know, accepted X amount of money for property located at such and such address for a period of time.
Yeah, I mean, even if they're not willing to give a receipt, to the extent that the tenant is able to write it on, you know, so if it's a money order, you're specifically writing in the money order what you're paying for and what month it applies to, and just keeping your own specific record, even if they're not giving you a receipt. Ideally, they're required to give you a receipt, but that doesn't always work out that way.
And this is where the text issue is helpful, because if you get a text from somebody saying, you know, your landlord Bob died, I'm his daughter, I'm going to be collecting the rent, that puts you in a really good place when you go into court. So those are the ones to save. And, you know, if you've got somebody claiming to work on behalf of the landlord who passed away, you want to save any notes or any information you get saying that.
All right, so back to a conditions question. What are the landlord's responsibilities as they relate to pest control and extermination?
Landlord has an obligation to generally keep the property free from conditions that will invite pests. So that's where I was talking about, you know, holes in the foundation, holes that go to outside. Tenants have a responsibility to keep their property as clean as they can to limit the invitation to pests. Landlords can't just say, I won't exterminate, but if the tenants are causing the condition, the landlord can charge the cost back to the tenant.
Great, and our final question, unless somebody wants to get another one in there quickly. If the landlord refuses to cover a stay while the unit is being remodeled at the landlord's initiation, what can the tenant do?
I guess that partly depends on how is the landlord getting the tenant out of the unit. I mean, the tenant could say, I'm not going to go, give me a notice. Depends on what kind of a rental agreement the tenant has. If the landlord suddenly decides to remodel in the middle of a 1-year lease, I think the tenant could say, I'm not going to go, you're just remodeling, this is cosmetic. I'm not going to go unless you give me a way to be somewhere else for a couple of weeks. They could also go to the court, I suppose, and try to get an injunction preventing the landlord from doing anything to remove them from the unit. Bobby or Hazel, anything else that you can think of?
No, yeah, that's where I was headed with some sort of injunction or TRO or a temporary restraining order.
Okay, so we do have one more. Hazel, you might want to stay on. The City of Cleveland has a right to counsel program to assist with questions, advice on the legalities of issues. Is there an agency or counsel for the surrounding suburbs, Bedford, Warrensville, etc.? What is the law and how many children to a room? That was the question someone else also had that I thought we would talk about in the next session in terms of number of family members per number of bedrooms. But could you speak to the right to counsel question?
Yeah, so right to counsel right now is it's only in the city of Cleveland. And as Bobby mentioned, it applies to families who are at 100% of the federal poverty guidelines and who have at least one child in the household. The interpretation of that is it's broad, so it doesn't require that it be a biological child. It just, there has to be a child that spends a significant amount of time in the unit. With regards to the suburbs, there isn't right to counsel in the suburbs yet. We do still, that doesn't mean that legal aid would not take on that case though, because keep in mind that right to counsel is only one of the programs at legal aid. So there is a chance that somebody could be reaching out to us with a housing issue in the suburbs and we would still represent them. So just because there isn't right to counsel doesn't mean they might not get an attorney. So you should consider referring them to us.
Great, thank you. And there was a request for that number for the Cleveland Housing Court Specialist, which I just posted in the chat for folks who didn't catch it on the slides. And we are at 3:01, which means it is time for our next break. We will resume the training at 3:15 and hear more about fair housing and reasonable accommodations. So enjoy 15 minutes. Great, it's my pleasure to introduce Hazel Remish, who you have all heard from already a little bit today, my colleague in legal aid, to speak further about fair housing issues and reasonable accommodation. So Hazel, please take it away.
Hi, everyone. Okay, so we're going to talk about the Fair Housing Act and what is it. Hopefully you'll have a basic understanding as to how to spot some issues with the clients that you're working with after this presentation, and just some tips on what you can do and how you can assist your clients navigate that process. So what is the Fair Housing Act? It was passed after the assassination of Martin Luther King. It was really meant to correct discriminatory governmental policies such as redlining and restrictive covenants, and some of these policies that were put in place to really hold back specific populations. It is a federal law that bans discrimination in housing related transactions. And we're going to talk a little bit about which transactions it applies to in one of the slides here. And really it's a civil right. And what is it and what does it do? So it prohibits discrimination on the basis of race, color, religion, or national origin. And we're talking about it in the context of the sale, rental, or financing of housing. So for example, refusing to rent or sell housing or providing different housing or services to a different population would fall under the Fair Housing Act. Affirmative rights for people with disabilities, so reasonable accommodations and reasonable modifications are covered under the Fair Housing Act as well. And I'm gonna we have slides specific to those, so I'm not gonna go into it just right now. And so we're really talking about people, places, and things. So people, there's protected classes. Property, the definition, it includes pretty much anywhere where people can live. Well, not everywhere. We're gonna specify that in a minute. And prohibited acts are illegal practices. And I just wanna point out that this is a Fair Housing Act at a federal level, but it exists in multiple levels. Not only at the federal level, but Ohio has its own state Fair Housing Act, and Cleveland has one as well. And many jurisdictions have their own with different additional protections that the fair housing, that the federal level doesn't include. So at the federal and state level, we're talking about, these are the protected classes right here. So they are protected from housing discrimination, national origin, religion, color, race. Gender was added in 1974, disability in 1988, familial status, which we're gonna talk about that question in the chat, and military status was added in Ohio as well. Cuyahoga has its own additional protections. So in 2018, it became the first in the state to adopt legislation, anti-discrimination protections for the LGBTQ community across all 59 municipalities in the entire county. So for this particular presentation, I just wanted to highlight that it's illegal to discriminate against anyone in housing, employment, or public accommodation based on the sexual orientation or gender identity as well. That is an added class. And then, as you all know, people of color are often overrepresented among the homeless population. So for example, in Cuyahoga County, 70% of the people who are homeless and 80% of homeless families are African-American, whereas only about 30% of the population is African-American. And in addition to that, in 2017, there was a statistic that came out that 20% of the homeless households in Lorain County were victims of domestic violence as well. And then people with disabilities, single mothers with children, seniors, veterans, and formerly incarcerated people are usually more vulnerable to housing insecurity and homelessness. And as we've been talking about here about evictions, I just want to sort of highlight that, you know, once a person goes into, there's an eviction action filed against them, there is a more likely a chance that they're going to spiral into that cycle of into homelessness as well. So it's just something to look out for. And in your roles, you're likely going to encounter folks who have faced unlawful discrimination and who are a greater risk of homelessness and housing insecurity, and often informed by their identities and their experience. So you should be looking out for that and refer them to us or refer them to your local fair housing programs for assistance. So I also want to highlight that there are other, Fair Housing Act is just one area in the law that offers these protections, but it's important to also talk about Section 504. And with respect to any program that receives federal financial assistance, there are some additional protections here for accessibility services, accessibility, delivery, employment, and the administration of programs. So this deals specifically with a disability, but I just wanted to highlight it because sometimes I think there's like a misconception that fair housing applies to housing, but there are other protections in terms of how programs are run as well. And I just wanted to throw that in here. And then again, the ADA and HOPA, both of these are also additional protections that regulates places of public accommodation and services operated by private entities. So, you know, many of you are probably familiar with the ADA, but it's just another protection that I wanted to highlight here. But we're not really going to talk about it in detail, but I just wanted you to know that there are other protections that exist as well. And then with the ADA, it requires that facilities that are open to the public consider the needs of persons with disabilities. So that's when we're talking about, you know, leasing or coordinating intake offices and how are they accessible to the public. That when people with disabilities visit those facilities, that they have access to all the services and all the amenities that anyone else who would be visiting the facility would have. And then HOPA amended the Fair Housing Act to permit certain properties for older persons to exclude children from residency without being liable for discrimination on the basis of familial status. So this essentially is kind of what creates senior housing. So what are prohibited acts? To refuse to sell or rent after the making of a bona fide offer, or to refuse to negotiate for the sale or rental of or otherwise make unavailable or deny a dwelling to any person. And you're discriminating against that person in the terms of conditions or privileges of the sale or the rental unit in connection with either their disability, their race, their gender, the protected classes that we just talked about. So types of discrimination. You have disparate treatment. So discrimination that is treating someone differently because of their race, color, sex, religion, national origin, or discrimination by a different impact. So where there's a neutral policy that's been set in place, so we're going to set up this policy for everyone, but it has a disproportionate impact on a protected class. And so that makes the policy itself have a disparate impact that makes the policy discriminatory in some fashion. So I think this is where you all can play a huge role. So reporting housing discrimination. So anyone who believes that their fair housing rights have been violated can pursue the matter through filing a lawsuit in state or federal court, which of course you need an attorney to do that. Filing an administrative complaint with the HUD's Office of Fair Housing and Equal Opportunity, the Ohio Civil Rights Commission, but more importantly, I think the advocates that you're going to want to be reaching out to are your local fair housing office. So if you're in Cuyahoga and Lorraine, that would mean the Fair Housing Center for Rights and Research. If you're on the east side, there's they have a fair housing center too, but generally most jurisdictions have a fair housing center. And that's who you should be talking to if you feel like that there is a violation. Oftentimes the local fair housing office can actually do what's called an investigation. So if there's a violation of some sort, they can send out a tester to see if a particular landlord engages in the same behavior with a different person. And so a lot of times they call that testing, and they can do that as part of the work and their investigative work to help bolster the case if there is a violation there. So this is a list of what are covered transactions and covered properties. So that's what kind of things are we talking about? So housing for rent, housing for sale, the sale of a property on which housing may be built, homeless intake and shelter placements and stays, mortgage lending, homeowners insurance, brokerage services. Covered properties are this list right here. So apartments, single and multifamily homes, condominiums, student housing, homeless shelters, transitional housing, group homes, permanent supportive housing, and assisted living. I just want to note that hotels and motels are generally not included under a covered property. So pretty much if you cannot register to vote at the place where you are staying, it is not going to be a covered property for purposes of the FHA. So protections on the basis of sex. It prohibits discrimination due to one's sex, one's status as a victim of domestic violence, regardless of the gender of the victim, one's nonconformity with sex role stereotypes, sexual orientation, gender identity, and sexual harassment. So here I just want to highlight that every one of us is protected by the fair housing laws in this context. We all belong to one or more protected classes. We are protected from discrimination based upon our sex. And this particular protection was added in 1974 to afford protection to women, but it has been interpreted to prohibit discrimination regardless of one's gender. So, and for example, there was a case that came out of Akron, I believe, where a man was denied an apartment because his girlfriend, an apartment with his girlfriend because the other units were occupied by single women, and that act was found to be discriminatory. And then in 2011, there was a memo issued by HUD and essentially finding that victims of domestic violence are protected by the fair housing law as discrimination on the basis that it would have a disparate impact on that particular population. So beginning in 2010, HUD began officially accepting complaints of discrimination due to nonconformity with sexual stereotypes. And so this is yet another one of the, this isn't necessarily the Fair Housing Act, but I wanted to highlight because they often are seen as hand in hand. So VAWA is separate from the FHA. So it is a different protection, but it is significant in addressing the rights of victims of domestic violence living in housing with federal financial assistance. So VAWA applies to only in federally assisted housing. It prohibits public housing authorities from denying admission to victims of violence. It prohibits evictions from public housing, voucher programs, and other subsidized housing such as LIHTC on the basis of domestic violence. a person can't be terminated from their tenancy or their occupancy rights. And it creates an emergency housing transfer option, which I'm going to talk about in a second. And the protection is afforded to, lesbian, gay, bisexual, transgender, and heterosexual. Everyone is protected. And so I just want to talk about the housing transfer options here. So oftentimes I think you'll see, at least we see these cases at Legal Aid, and I assume you might be seeing some of this as well, where you'll have a victim of domestic violence who lives in a federally assisted building of some sort or federally assisted housing, and something happens that he or she is no longer safe or feels safe in the unit that they are at. If the person lives in a project-based Section 8 type unit, there is a transfer network that has been established so that if safety is an issue, they can transfer to a different unit and not lose the subsidy or relinquish the subsidy. In the voucher context, one of the things that we see sometimes is, during the first year of the lease, a tenant is not allowed to break their lease. They have to live in the unit for a full year. But if there's an instance that happened where, for example, they were attacked on the property or some incident of domestic violence occurred, they can ask to be released from that first year restriction pursuant to VAWA. So this is a useful tool for victims of domestic violence and who are specifically living in federally assisted housing. So reasonable accommodations. First, I just want to say there are no magic words in order to have a client request a reasonable accommodation. So what it means is it's an adjustment to rules or policies or practices or services that need to be adjusted because they are considered, the person is considered a protected class. So they have to be made. So that means that the landlord or the owner of the building has to make the accommodation unless it would cause an undue financial and administrative burden, or unless fundamental alteration in the nature of its program, or the person is a direct threat to him or herself and others or the property of others, and no possible accommodation will remove the threat. So essentially you want to look at it as, is it an undue financial burden to the landlord? Does it change the way that they're running the building in some fashion that is unreasonable? And is the person a direct threat of some sort? So this sometimes comes up in cases where somebody got off their medications, for example, and they're engaging in behavior that, the landlord finds offensive, or in, criminal activity even, for example, and it ends up in eviction court. And a lot of times what we'll raise is if it's connected to the person's disability in some fashion, we can say we're asking that the eviction not go forward because we're raising the reasonable accommodation as a request, where the client has now gone back on their medication. We can show that they're no longer going to be that direct threat to themselves and or to others. And so that's one way that we often will see this come up. But like I said, there's no magic language. A tenant can say, for example, to a landlord, oh, after I had that heart attack, I'm really having a hard time, with A, B, C, and D. And that might rise to the level of the landlord should be able to recognize that is could potentially be a request under the FHA for an accommodation of some sort. So examples of accommodations, allowing a working or therapy animal to live in an apartment where the apartment normally would have a no pet policy. And we see this pretty regularly sometimes, especially with multi-unit buildings or subsidized unit buildings. Providing a reminder that rent is due on the following day for a person with a disability, I can't say the word right now, developmental disability. So that is something that we've seen. Another one that we've seen is cases where, for example, somebody is on SSI and their check doesn't come in until the 3rd of the month. or the 5th of the month, and their rent is due on the 1st, and it's causing for their rent to be paid late every single month. So an accommodation could be that they move the due date of the rent to accommodate the person. To provide a reserved parking space when otherwise it would not be available to them. So like in the example that I just gave you, I really had I had a heart attack, and now I'm having like a really hard time breathing and walking all the way to my car. And so this could be an accommodation that the landlord can provide. And then the last one that I have here is related to providing written material in a way that the person can read them. So whether it's a large print, braille, or for vision, if you're vision impaired. But then otherwise, I also wanted to mention that's not on the slide, sign language would be covered here as well, interpretation. Wait, I don't know where the rest of my slide just went. 1 minute. I need a minute for technical difficulties because I had a section on modifications. So Anne, give me a minute.
No problem, Hazel. Take your time.
We're all relaxed from that beach picture anyway, that beach, so it's like a moment to breathe. So.
That's right up your alley. It's in Michigan.
Is it?
Yeah.
There's a question in the chat that I'll just comment on, which is, what about if a person is knowingly illiterate? And we have struggled with this for a long time at Legal Aid, and I would invite, Barb or Hazel, once you get things situated, to come back to this, but it's not, there could be an accommodation if there's an underlying disability that relates to the literacy. So certainly in the context of school issues, sometimes that becomes a factor, but on its own, I don't believe there's any law that protects a person for literacy by itself, which is a challenge. So I appreciate the question and raising that issue. I certainly will.
Yeah, I mean, that's been our experience as well. Unless it's connected to some other disability, there's no protection.
Hazel, do you want me to see if I can pull up the slides?
I have to log into the K drive, fortunately.
I
really thought I had it all together.
You're fine, but I have open if you want me to just share.
Okay, do you see the modification section on there?
That's a good question. Let me check. People, places, things, classes.
Yeah, I see it in mine here.
Okay, if you can get to it faster, go for it. No, I ended the one I have is it ends at examples of accommodations, unfortunately.
Okay, I have it. Sorry, everyone. I'm getting it. I can take a question if you want. Will I
pull this up? Well, the other question went back to the VAWA conversation and whether it would still apply if the tenant is consistently inviting or allowing user who is not on the lease to have access to their unit. Would they still be afforded those protections?
Yeah, that's so the victim is inviting the aggressor.
Correct.
Yeah, that would probably not be covered.
The other question that had come up earlier was whether the fair housing protections that you went over, Hazel, do any of those apply in the context of someone in a nursing home?
I don't know. Do you know him?
So I don't think, I think some of them apply to nursing homes, but not because they're housing. I don't know that exactly, but I think certainly the ADA would apply to nursing homes. But I'm not sure if it applies under the prong as a housing provider, right? So that's the piece that I'm not sure of. I think there's, and I don't know whether or not the Fair Housing Act applies to nursing homes. But it,
I would guess not, but I don't really know. I should pause for a second and answer the familial status question that was in the chat. So an owner of a building or residential dwelling can limit the number of people that are living in the units, but they cannot say we won't rent to, because, you know, we will only limit it to 2 children, for example. And then the other scenario that the other question or follow up to that was how that plays out in the voucher program, for example. And in those instances, the housing authority can tell tenants that they are either underhoused or overhoused and that they need to move. In those instances, it's more based on the size of the unit. Is the housing authority has determined how much they're going to pay for the unit based on the household size and the requirements that they have to have certain bedrooms available based on gender and number of people in the household. And so there is a formula that the housing authority has used to calculate that, so they can tell tenants that they are either underhoused or overhoused and require that they move. But that's the housing authority, not the private landlord taking that action. So we were talking about accommodations and the idea that what are some examples, and the idea that as long as they are not, the person is not a threat in some fashion, there isn't an undue financial burden, and that that it doesn't change the way that the building or the dwelling is being run generally, that they would be required to grant them. So a request for an accommodation can be considered unreasonable and not granted if it would require that fundamental alteration in the nature of the services, program, or activity, or the request is an undue financial and administrative burden. So it's just the flip side of it has to be granted, but if it's one of these, the landlord can say, look, we want to do it, but it's changing the way that we operate the building, and it's too expensive for us to do that. And so we're not going to do it. I mentioned that we see a lot of cases where they're asking for an assistive animal. And we see it in the context of landlords saying you have an unauthorized pet in your unit. And so we're going to evict you because you have this pet that was not authorized. And so an assistant animal is not a pet. It could be anything. We normally think of it as a dog, but it can be anything. It could be a cat, a bird, a guinea pig. And it does not have to be professionally trained. So, oftentimes we think of it as a dog that needed to be professionally trained to provide that service. And it does not have to. It could be a support animal that would be sufficient in order to invoke this protection. One other thing that we've seen is asking for the accommodation as a way to terminate the lease. So, Barb talked a little bit about termination of leases in the context of like conditions issues, but there are also, instances where a tenant might have to terminate their lease either because, the example that I have on here is they have like an allergic reaction to something and the landlord ignores it. Or, and in that instance, when the tenant breached the lease, even though there was still months left on the lease, the court determined that the legal action to secure the balance of the lease with no special efforts made. So essentially, the landlord was suing the tenant, trying to get the remainder of the lease. And the court said, well, the landlord didn't take any action to mitigate the damages, and that was a fair housing violation. The other example that I have here is a case where the court determined that it was unlawful to ignore a deteriorating mental condition and imposing on the tenant who moved out with a notice of refusal to refund the security deposit, a reletting fee and charges. So essentially, tenant moves out, landlord knows, is on notice that the mental health condition of the tenant was deteriorating, but yet the landlord goes ahead and pursues the remainder of the lease and is trying to collect a late fee and trying to charge the tenant because the unit sat vacant for a period of time, and the court said that that was not allowed. So HUD regulations waive to accommodate people with disabilities. So for example, a tenant with a significant disability wants to use their Section 8 voucher to live in a home that is owned by a family member. That technically is not allowed under the under the Section 8 program, but the tenant can request, and in the example that I have here, where they have a caregiver, for example, that the housing authority waive the regulation and we consider that a reasonable accommodation based on the severity of the disability and the absence of any other way to compensate the brother. So in this case, brother was caregiver, owned the home. Generally, a person with a disability, a person would not be able to use the voucher there because it's a family member. But in this instance, the court said that they could, and we were going to waive that requirement as an accommodation because of the disability. And we've seen that case come up pretty regularly, actually. And I talked a little bit about this in the context of my hypothetical client with a heart attack who couldn't walk to the parking lot, and so that is one of the instances where we see the issue come up as well. And then, so what happens after the person has requested the accommodation? If they refuse the requested accommodation because it's not reasonable, they have a requirement that they engage in this interactive process. So essentially, the landlord has to discuss with the tenant whether there's an alternative accommodation that could effectively address the need. Without going into that interactive process, they have failed to comply with the Fair Housing Act. And then reasonable modifications. So as opposed to accommodations that are a change to policies or procedures, modifications are actual changes to the physical characteristics of the residence. So for example, you need a higher cabinets or lower cabinets or some other, a ramp, for example, that would be considered a modification to the residence or to the common areas of the building that would be protected. So structural changes to the existing premises may be necessary for the person to fully enjoy the premises like everyone else would. So they do require prior landlord approval. You have to get somebody to do it in a workmanlike fashion. Permits are required, and it could be at the expense of the person with the disability. One exception is subsidized housing. Subsidized housing the burden to pay for the modification could be on the owner or the landlord. And so these are just some examples. And then so installing a ramp, grab bars, we see that sometimes, especially in bathrooms, widening doorways or installing a lift. And then again, for federally funded communities, so in federally funded community that has programs for people with disabilities, a manager can ask an applicant or resident for more information if the existence of the disability is not obvious, and they can actually require written verification from a third party as well. So I'm gonna stop sharing. I do think that's the actual end of my slides this time. And Angie, you want to take questions?
I am busy trying to find my buttons. All right, thank you so much, Hazel. So let me get the chat open. I know we had a couple of questions pop up. So if you can see it, go ahead and dive in, Hazel. I'm still finding control.
Yeah, so there's a question here about where the tenant has a support animal but refuses to complete the reasonable accommodation forms. If the tenant will not complete the forms and provide an emergency contact to care for the animal in case they are unable to, are they then violating the lease? I would say yes. So it kind of depends. So some properties actually have like created certain forms that are required that they be filled out. And we have gotten into, and in some instances they say, well, they didn't complete it. And my argument has been, well, you were on notice that there was a disability. You were on notice that this was the accommodation they were asking for. And there's no requirement that there actually be an application of like a specific application that they have to fill out. And I actually litigated that case. It was not in the context of an animal, but it was in the context of an unauthorized occupant. Somebody had moved in to assist the tenant with their daily life activities. And so in that instance, I think that the argument from the landlord would be that that is a violation of the lease. And in some instances it might be, but you can potentially argue that it's not if the landlord was on notice and there's the tenant has requested the accommodation, even if they haven't filled it out in writing.
Thank you, Hazel. The next question, we have patients who come to us seeking a letter for support animals. Generally, our practice does not write them. Suggestions about where to refer people or how to handle this. And what immediately comes to mind with this question for me is, who's responsible for approving what? So if you could talk a little bit, Hazel, about, a tenant's allowed to make a request. And in some circumstances, the landlord can ask for additional documentation, but that might not always be necessary.
Yeah, it's not always necessary, especially if the disability is obvious. So, in the instance of a pet or an assistive animal, that might not be the case, or a support animal. It might not be immediately obvious why the tenant would be making that request. And so in those instances, I don't necessarily think it has to be like from a doctor, for example. It could be a case manager. It could be some other person who is providing any other level of care or support for them. It could even be a household member, I think, that can provide some sort of documentation as to why they need it. But it's not always necessary that you have that third-party verification. Do you want to add anything, Anne?
I want to go back to the prior question just for a minute, because I think underlying this is a different issue that does sometimes come up, which is that certainly requesting a reasonable accommodation does require that the person be willing at a minimum to acknowledge they have a disability. And certainly some folks don't want to do that. And that is understandable and very real, but it is a question people have to grapple with, because if they're going to request an accommodation, they are inherently going to have to reveal the fact of some disability to the entity they're requesting the accommodation from. How much detail they give on that disability may or may not be necessary. So, we can certainly support people in giving only limited information about the nature of the disability, but some amount of acknowledgement that they have a disability is inherent in making the request. So to the extent the folks you're working with are trying to avoid even having to say that much, that does become a real barrier. We have some new questions popping in. Can the landlord charge an animal a security deposit fee for an assistive animal?
Hazel, wouldn't that be the same as like, can the landlord charge for the installation of a ramp? And doesn't it depend on the type of property that they're in?
Yeah, I think it would depend on the type of property that they're in. I know that we, have had cases that come through where, for example, the housing authority or some subsidized landlord will have a no pet policy, and or they have a policy that allows you to have a pet but requires that they pay this fee. And in those instances, we've argued, well, this isn't a pet. And so you should waive that requirement. I think it sort of depends. And I don't know the definitive answer, to be honest.
What about if an animal is left unattended in a unit for several days? Landlord have access to have the animal removed.
Barb?
I think that would be in the same sort of emergency circumstance issue that we've talked about, the other access questions. If it's fish in a bowl, I think there's no reason to go in and take them. Well, you might want to feed them, but you know, fish in a bowl for a couple of days are probably going to be okay. You know, dog unattended, that's going to come up faster, but I think it's just, is it an emergency? And that could include evaluating whether the animal is safe and also whether it's destroying the property. And if it's a pony, then it might be a destruction of property issue. So.
Great. So thank you so much, Hazel. That I think covers all of our questions. If I missed anything from anyone, or if somebody's been trying to raise their hand or wants to jump in, please unmute yourself and just interrupt me, because I may not be seeing you with so many folks on the training, but this has been a fantastic conversation. I really appreciate the engagement. I know it can be hard to do that virtually, and our presenters, thank you all so much for sharing your expertise and experience with everybody. As a reminder for anyone looking to get continuing education credits, please be sure that you return the evaluation that I will be sending out to all the participants. I'm going to confirm with our presenters afterwards, but I expect to be able to share the materials that were presented today, as well as the overview information about legal aid. So you will have that following today's presentation. We do post these recordings along with the recordings from our prior trainings on financial matters and on family matters to our YouTube page. So I'll put that in the follow-up email, so you'll have a link in case you want to go back to any of the trainings that you missed. With that, thank you all so much for attending today. I hope you have a great afternoon, and thanks again to my colleagues for sharing your expertise. Have a great day, everyone.
Thank you.